Everyone, it's James from Community Legal Centres Queensland. Welcome to our webinar looking at recent cases in family law presented by Clare Dart from the Queensland Bar. Can I begin by acknowledging the traditional custodians of the lands on which we're magically meeting through the miracles of modern technology. Where the Community Legal Centres Queensland office, I acknowledge the Yagara people as the traditional custodians of this land. We've got people tuning in from across the country, so I acknowledge that we all live and work on Aboriginal land, and we pay our respects to elders past and present, and any Aboriginal or Torres Strait Islander people who might be joining us today. In the last 10 minutes or so, I've emailed around a copy of Clare's PowerPoint presentation. You should also be able to download it from the handouts section on the GoToWebinar control panel, so that you can keep notes as you go. Hoping to have a recording of this made available and distributed, technology willing. It's not always. We'll see how we go with that. A couple of ways that you can ask questions. We prefer that you hold your questions until the end of the presentation, just because webinars work a little bit better that way. There are two ways that you can ask questions. One is to press that button that looks like a hand on your control panel. You'll see something that looks like a hand going up for you, and unmute your microphone. You'll then be able to ask a question directly. The other and maybe easier way to ask a question is to type a question into the questions box. We'll see it pop up here, and we'll read it out or paraphrase it or something, and Claire can answer your question. If you've got a pressing question, feel free to throw it in, but our preference is probably that you hold your questions over until the end. That's my introductory and housekeeping stuff. Can I introduce Clare Dart, who was shanghaied into doing this at relatively short notice by a colleague at the bar, and has been very generous and stepped up to deliver a case law update on family law. Clare has worked in legal aid and at the private bar, specialising in family law and different aspects of family law, and today will be providing us with a bit of an update on recent developments through the courts, predominantly in the family law courts, but also looking at a couple of Queensland DV related decisions that may also apply in other parts of the country as well. Clare, thanks very much for being involved, and just bear with us folks as we change out our chairs. Thanks, Clare.
Thanks, James. Good morning, everybody. I'm not entirely sure where you all are out there this morning, but hopefully you're all safe and dry. I have to apologise firstly, of course, for the change in terms of the dates. Those of you who are in Queensland probably can have some insight into the crazy weather that we were having last week, and the reasons why the seminar was postponed, but hopefully none of you have been adversely affected by that weather. In terms of the case update today, there were a couple of key areas where I was planning just to focus on, and they are in relation to a relocation decision, substantial and significant time, a recent decision from the High Court, dealing with disputed evidence at interim hearings, an interesting case about dogs, and then a couple of domestic violence cases. So hopefully they'll give you a bit of an update in terms of some of the issues that are arising before the court. So firstly, in relation to relocation, one would have thought that this was a fairly settled area for all of us. Sorry, just working out the technology here. There has been a series of full court decisions in relation to the issue of relocation, and in particular, of course, those decisions have indicated that the court has power to make an order requiring a parent to relocate a child's residence, and that authority lies either in section 65D and 68D of the Act. The full court also said in Hampton and Hartnett that that power may also be apparent under section 1143 of the Act, provided, and obviously for those of you who practice in the area will be aware that that's an injunction provision, that provided the injunction is no more than is necessary to secure the best interests of the child. In terms of the current position, Adamson's probably one of the more recent full court authorities in relation to the area, and it referred back to Sampson, and it talked about the exercise of the power to require a parent to relocate a child's residence, indicating it would be likely to be rare to have to use that coercive power. and that orders made pursuant to an exercise of that discretion would be at the extreme end of the discretionary range. And it follows that there should be rare or extreme factors that warrant the court exercising its discretion to make coercive orders requiring a parent to relocate so as to continue to be the primary carer of the children. The court went on to say that to order someone to relocate to another place will require the court to be satisfied that the practicalities of life equally or sufficiently exist in the place to which the party is required to move. And that, of course, does require the court to give consideration to those matters. The full court in Adamson also referred back to AMS and UNU and confirmed that there is no requirement for a parent to demonstrate compelling reasons as to why they should live where a parent proposes to live, or that whether that be a proposed new location or in their current place of residence. So that all seemed pretty settled, and you might ask, why are we talking about this again? It's been those authorities have been around for some time. The reason I'm raising it this morning is that Judge Brewster in the Federal Circuit Court, in a recent decision of Needham and Cassidy, essentially concluded in that particular case that the court had no power to make an order requiring a parent to relocate, or at least the power to order an interstate relocation. What's interesting about that particular decision is he notes that his findings are inconsistent with the conclusions of the majority of the judges in 4 decisions that he referred to in the full court. Sampson and Hartnett was one, Adamson was another one, and then there was Zander and Ember and Asadi. And he acknowledged that there was only one judge who doubted that the court had power. But in his view, the observations of the majority of the judges in each of those decisions were open as dicta, and on that basis he concluded that the court had no power to make the orders requiring the relocation. Now, you might be wondering why we're talking about a single Federal Circuit Court judge versus, I guess, the full court, for want of a better word. But the issue is that a number of the Federal Circuit Court judges have now been asking for submissions in relation to the basis of the power, because they've obviously read this decision from Judge Brewster. I should indicate I respectfully disagree with Judge Brewster. I think that the authorities from the full court are clear. The full court has found that the court does have power, and it comes from those sections that I referred to right at the beginning. But I'm raising it with you because you may need to argue the basis of the power to order the relocation if you're having running matters, whether they be on an interim or a final basis before the court. So I guess it's a bit of a watch here. I'm not sure if there will be an appeal in relation to Judge Brewster's decision. One would anticipate there should be, but I guess time will tell in relation to that. But in the meantime, as I say, a number of the judges have been asking for submissions about it. So if I can move on then to the issue of substantial and significant time, and what does it mean? Obviously, the provisions of the Family Law Act do set out in some detail what substantial and significant time is. There is some questions, though, I guess, in terms of whether all of the requirements of the sections need to be met or otherwise, which is why I want to talk to you today about the case of Ulster and Viney. In this particular case, there were 2 children, a 9-year-old and a 7-year-old. The mother had relocated with the children from Melbourne to Gippsland. Prior to the move, the children had been spending time with their dad each alternate weekend from Friday to Sunday and overnight on the alternate Wednesday. They also spent some time with him on alternate Mondays, which coincided with their piano lessons. The father filed an application seeking the mother return to Melbourne, and there were some interim consent orders reached, and they essentially provided for what was a shared care arrangement, but it was 6 nights a fortnight with dad and 8. Sorry, my math is terrible. Yes, no, 8 with the mother, and some shared school holiday periods. So it was, one might ask how they got to that arrangement on an interim basis given the previous arrangements, but I suspect that they may have been influenced somewhat by the fact that the mother was actually working in Gippsland, and so she had to rearrange her work commitments around the times when the children were with her, and ultimately she had to rent accommodation back in Melbourne for when the children were spending time with her, and she stayed with her mother and stepfather when she was doing her work in Gippsland. In that particular matter, the primary judge allowed the mother to relocate the children's residence and ordered, in effect, that the children spend time with their dad on alternate weekends, and then on the alternate Friday night from after school until 7, for 10 days during each school holiday period, and there was some additional time ordered during Christmas school holidays and special days. So it was essentially time each week, because you had that after school time on the Friday each week effectively. But the father, of course, wasn't happy with that. What's interesting about this particular decision is that there was a dissent judgment written in relation to it, and I'll come to that. But the primary judgment was written by Ainsley Wallace and Ryan justices, and essentially they referred to a case of Eddington where the full court stated that although orders for time to be spent with a parent might fall literally within the provisions of Section 65 DAA, 3A, B and C, it doesn't mean that the orders thereby provide for substantial and significant time, and that what constitutes substantial and significant time is going to vary from case to case. So in essence, they said that the test was, first of all, it was mandatory that there be compliance with each element of Section 65 DAA 3, and then if that's in the negative, then the orders can't be substantial and significant. If it's in the affirmative, then it's necessary for the court to go on and consider whether, in the factual context of the case, the time is both substantial and significant. So it's really that two-part test that the hurdle that you need to get over in relation to that. Justices Ainsley Wallace and Ryan indicated that the section doesn't limit the question of involvement in daily routine to school weeks. And that's key, because a lot of people obviously suggest that to be involved in the daily routine you need to also be involved in all the schooling issues as well. They went on to say that nor does it require involvement in each and every aspect of the child's life, and that the section does not require daily physical association with each and every procedure or activity that occurs each day or each weekday for the children. They looked at overall what the orders that were made provided for, and indicated that they provided annually for the children to spend something like 95 to 100 nights with the father, and found that no doubt provided the father with an opportunity for active participation or involvement in the children's daily routine, albeit they did acknowledge that it would be to a limited extent during the school week. But in their view, the orders satisfied each of the elements of Section 65 DAA 3. So then they had to turn their mind to whether or not in the circumstances of this particular case was the time substantial and significant. And Justices Ainsley Wallace and Ryan found that it was. Now, as I indicated, there was a dissenting judgment which was by Strickland J in relation to this matter, and he said that he would allow the appeal. He didn't agree with the majority view that the orders could probably be said to provide substantial and significant time. He agreed with the submission by the father's counsel that substantial and significant time is that time sufficient to enable the children to feel that their parents are involved in all aspects of their care, flowing from them being exposed to their parents in a variety of settings. I think that submission is somewhat interesting in terms of saying all aspects of their care, because even in intact families there may be parents who may not be involved in all aspects of children's care, particularly there might be parents involved in shift work or not engaging in certain sporting activities and those types of things. So it's certainly a fairly high bar, I would suggest, if that were to be the case. He went on to talk about such settings including activities on holidays and weekends, and day-to-day reality of the child's life, such as supervising homework and bedtimes, imposing day-to-day discipline, collection and delivery from school and sports training. And I guess there's a bit of an argument in terms of those orders in this particular case. Certainly they would have seemed to have covered some of those matters that are referred to there, but perhaps not necessarily the sports training, although I'm not aware of any particular evidence in terms of sporting activities on the weekend for children. So I was going to look then at issues of disputed evidence at interim hearings. These are often a difficult issue for all of us, particularly in cases, in my experience, involving family violence, because those are issues that are often disputed at an interim time, and there may or may not be any subpoenaed material that will assist in terms of that. You'd all be aware that rarely do you get a case where there's actually, medical records or police records that actually support what the parties say, and that makes it all the more challenging at an interim hearing. So I wanted to talk about a decision of Eby and Spielman, which was also a relocation matter. In this particular case, the mother relocated with the children to a town about 9.5 hours drive away from the father. The judge ordered that the mother return the children and made orders for time for the father. The mother appealed that decision, and it's a fairly short judgment, so it's worthwhile having a read of. The appeal was allowed because essentially the court had found that the judge had failed to address Section 65 DAA. But what's interesting about the judgment is that Ryan J, who wrote the judgment to which the other two judges agreed, indicated that there were two matters which he felt couldn't be allowed to pass without comment. And this is where this issue about evidence at interim hearings comes in. In this particular case, he said that the judge had identified 8 topics on which the parents gave conflicting evidence. In his view, they were matters of substance and they were relevant, obviously, to the case and the decision that needed to be made. It seems that from the judge's reasons on an interim basis that where there was evidence in conflict or it lacked corroboration, that evidence was effectively disregarded by the judge. And Her Honour indicated that proceedings were being determined solely on the basis of agreed facts. Brian Day referred back to good and good and obviously talked about the nature of interim hearings, meaning that the court could be drawn into issues of fact or matters relating to the merits of the substantive case where findings are not possible. But the full court in good and good obviously indicated that that doesn't mean that merely because facts are in dispute that the evidence on the topic must be disregarded and the case is determined by reference to the agreed facts. That there may not be enough agreed, as I'm sure you've all experienced, for the court to actually make a decision on that basis. So Ryan Day indicated that the proper approach to contentious matters of fact at interim hearings is as was explained in Marvel and Marvel. And in that case, they referred back to a decision of SS and AH, where the majority said that the findings made at an interim hearing should be couched with a great circumspect section, no matter how firmly a judge's intuition may suggest the finding will be borne out after a full testing of the evidence. The court went on to say that intuition involved in decision-making concerning children is arguably even of greater importance when a judge is obliged to make an interim decision following a hearing, at which time constraints prevent the evidence being tested. And that apart from relying on uncontroversial or agreed facts, the judge will sometimes have little alternative than to weigh the possibilities or probabilities of competing claims and the likely impact on the children in the event that a controversial assertion is acted upon or rejected. So that's obviously going to mean that the court has to do a bit of a balancing act in terms of any of those disputed facts. The court went on to say that it's not always feasible when dealing with the immediate welfare of children simply to ignore an assertion because its accuracy has been put in issue. So obviously the court can't just disregard everything that's in dispute. They're going to have to consider that and, if necessary, weigh it. So in this particular case, they said that the court can appropriately and carefully deal with contentious issues relevant to the welfare of the child, and those issues can't simply be ignored. So that poses, of course, some challenges for us in terms of making submissions, particularly in relation to interim matters, where there are issues in dispute. whilst ideally you would base your submissions on the facts that are agreed, obviously that's not always going to be possible, and you might need to point to some evidence perhaps that would assist the court in balancing the different competing versions, I guess, and anything that might assist them in making a decision in relation to what evidence they might accept. The second issue that was also raised is interesting, I suggest. In this particular case, the judge had remarked that the mother had not produced any independent evidence to support that the father had been controlling or abusive towards the mother or the children. And Ryan Day commented that much of what occurs in families takes place in private, and as a consequence, cooperation is often not available. And he went on to say that the absence of corroborating evidence does not necessarily undermine a person's evidence on that topic. So I think this is an important point because obviously domestic violence issues are, I think, becoming or spoken about a lot more. The court's becoming a lot more conscious in relation to those issues, and I think it's very conscious of trying to ensure that parties are not disadvantaged by a lack of corroborating evidence. I will mention at the end of the paper that the family courts have recently revised their family violence best practice principles, and there's a link at the end of my presentation in relation to those. And I would encourage you all, if you haven't had an opportunity to look at those, that you do so. And where appropriate, obviously, you can refer the court to those particular guidelines in terms of the approach to a particular matter if it's relevant. So one of the interesting things that's recently come through has been a decision from the High Court. We all get a bit excited when we get some High Court authority in the family law area because it doesn't happen very often. And some of you may have heard of this case of Bottlement because there has been a bit of interest in the media in relation to it, particularly in relation to the issues of the views of the children given their ages. So in this particular case, the parties were separated in 2010. There were two boys involved, one who was almost 15 and one who was almost 17, and a little girl who was almost 12. There have been some orders made on the 25th of June 2014, which provided for equal shared parental responsibility and also provided for parents to be able to take their children overseas on holidays, subject to certain conditions. So on the 14th of January 2016, the two boys flew to New York for a holiday. I should put that in quotes in my PowerPoint, I think, subject to with their father. And on the 29th of January 2016, the father tells the mother that he decided to live indefinitely in the USA and the boys would remain there with him. One might, of course, question that chronology in any event, but leaving that aside, the mother filed an application seeking the boys' return to Australia, and the matter came before Justice Watts, and he ordered that the boys be returned. And if the father didn't return to Australia and the boys didn't wish to live with their mother, then they could either live in accommodation with supervision paid for by the father, or they could live separately with mothers of respective friends of the boys. So somewhat interesting orders in that sense, because it seemed to be clear that the boys didn't necessarily want to live with their mother at that particular point in time. And interesting also that the judge obviously disregarded or placed little weight on the children's views despite their ages. So the matter, of course, went on appeal, and the full court dismissed the appeal. I should indicate that Ryan and Aldridge were together in terms of dismissing the appeal, but there was a dissenting judgment from the Paul Trench. So then there was a special leave application which was granted to the High Court, and subsequently the appeal was dealt with by the High Court. The High Court essentially rejected the father's contention that Watts J had erred in discounting the boys' expressed preferences to remain in New York because the judge had formed an adverse view of the father's actions. So that's obviously the actions of taking the boys on holidays and then telling them, oh, by the way, they're staying here. the court also found that the extent to which the boys' views had been influenced by the father was relevant to the weight to be given to them. And you've got to bear in mind again that these are almost 15 and 17-year-old boys. The court rejected the father's contention that Watts J was required to ascertain the boys' views as to the alternate living arrangements. So there was no evidence before the court as to what the boys might think about living in accommodation with supervision paid for by the father or living with their mates. But the High Court didn't have a difficulty with that and indicated that Section 60CC3A only required that the views of the children which have been expressed have to be considered. The other reason I wanted to talk to you about this case is that it's an interesting decision because there were orders made essentially in favour of the boys' respective friends' mothers who were not parties to the proceedings. And the court didn't see that as being an issue on an interim basis, on the basis that Section 64C permitted parenting orders to be made in favour of a parent of a child or some other person. I stressed that this was an interim decision, and whilst obviously that provides some support for being able to make orders in favour of people who aren't parties to the proceedings in parenting matters on an interim basis, I think it's still preferable if you are trying to seek such orders on a final basis that those persons be parties to the proceedings for a whole variety of reasons, that they probably need to be heard in terms of the orders being sought and ensure that they provide consent in relation to those matters. So, moving on then, I thought I'd talk to you about a recent decision in relation to a dog, because I know these things come up periodically. It's a federal circuit court matter by Judge Harmon. There was a property matter where the parties have reached agreement about all of the property matters except whether or not the husband should be required to effect a transfer of the registration of the dog to the wife. The judgment is interesting in that, excuse me, Judge Harmon goes through some authorities in relation to sentient creatures and talks a little bit about the definition of those, and there's various statements in relation to dogs more generally, but ultimately the decision was that the dog was a chattel and that the court did have the power to determine the ownership of it, and that the proceedings were not about the value of the dog per se, but in the parties' terms it was about the love and affection for the dog. The court did give consideration to the ownership, or had to determine the ownership of the dog, and the court found that who had paid for the dog was not of itself determinative of ownership or determinative as to what orders should be made. And there seemed to be no dispute in this particular case that the husband had paid for the dog. It seemed to have been that the dog was purchased prior to the parties commencing cohabitation, and it was some little time prior to the wife's birthday, and there was some issue about whether it was a gift and those types of things. There was a lot of evidence provided to the court about who'd been paying for vaccinations and other related expenses. And there seemed to be a dispute as to who had actually taken the dog home originally and those types of things. But ultimately the court determined that the wife was the owner of the dog. The court then looked at Section 75(2), but indicated it couldn't assist in terms of making a decision in relation to this particular matter. They did comment that if it was a service dog, then there might be some argument in relation to Section 75(2) on the basis of there should be an adjustment for a factor relevant in terms of determining the ownership in those circumstances. What was interesting then was the court also gave consideration to whether or not you could actually adjust the dog, and commented that if satisfied, an order should be made. The best that one could do, no doubt entirely unsatisfactorily to both parties, would be to find contributions equal and effect division of the asset. and I'm sure that no one wanted the dog divided up as far as that goes. Ultimately, the court decided that there didn't need to be any orders made with respect to adjustment of interest in the dog, and dismissed the application with respect to ownership of the dog. But they did order that the husband transfer the registration of the dog into the wife's name alone because he had been registered owner. So next time you have an issue in relation to a dog, it's probably a good authority to have a look at and perhaps to refer to in terms of how to deal with those issues. Just on the side, it's interesting that arbitration is something that we're hearing more and more about. I am on AFLAN's list of arbitrators, and I had someone approach me to see whether I would do an arbitration in relation to the dogs. I referred them off for mediation in relation to that, but anyway, it's interesting how passionate people are at times about ownership of the dog, and for good reason. Wow, we're moving through quickly. Sorry. It's different without having people asking questions along the way. So I was going to talk then about a couple of domestic violence and family law related matters. So all of you are probably familiar with the legislation in terms of the sections of the Family Law Act, and in Queensland we've got particular sections in our domestic violence provision that deal with the court's ability to revive or vary or discharge or suspend existing orders or injunctions under the Act. I should say that in my experience anyway, we're seeing more applications to vary orders in the family or federal circuit courts. There's been some reluctance in my experience from some of the federal circuit court judges to actually formally make orders varying them, and with some of them preferring that people go back to the domestic violence court and obtain a specific variation for particular things. I'm not sure if that's because it's relatively new, I guess, that they're being asked to do these things, and I would suggest to people that we should continue to make such applications because the more we do it, obviously, the more case law and experience there will be around it, because it can be an effective way to deal with those issues when you have an issue arise at court. So I wanted to talk to you about a couple of Queensland Queensland decisions in relation to domestic violence. The first one's a magistrate's decision in relation to a permanent stay of an application, and then the other two are in relation are appeal court decisions. So the first one was a decision of Magistrate Hasted at Roma. In this particular case, the aggrieved had made an application and then she had failed to appear, and the application was dismissed. There had been, in the interim, some written submissions delivered by the respondent for dismissal of the application on the grounds that it represented an abuse of the court process. But that application was not pressed as the application was dismissed on that first occasion anyway, because the aggrieved had failed to appear. The aggrieved though turned up at court later that day to discover the application had been dismissed and then filed an application in identical terms. So the respondents then made another application for dismissal or permanent stay of the application on the basis that it was an abusive process. So the court then had to consider whether the aggrieved application was genuinely brought for the purposes contemplated under the Act, or while she was normally seeking protection, it was substantially seeking to effect an outcome which would actually change the parent with whom the children of the marriage would live with. Because if it was the latter, the court was of the view that it would be an abuse of the court's process. So the court went through the aggrieved application and the basis on which she was seeking the order, and the court effectively found that the more dominant theme of the application was what the effect the children residing with the respondent had on her, whom the children would reside with in the future, whom the children would spend time with, and what retaliation she might suffer if she withheld the children in the future. The court then referred to these provisions in terms of the power to make orders that affect parental responsibilities of parents of children who are in dispute, and indicated that obviously it was only in very limited circumstances that the court would have power to do that, and made reference to Section 68R of the Family Law Act and Section 78 of the Queensland Domestic and Family Violence Protection Act. In this particular case, the court found that the predominant purpose of the application was to effect a change in the current living arrangements for the children of the marriage, with the subsidiary purpose of obtaining protection from any retaliatory acts should she be successful in that primary purpose. And as a result, the court found that the application for the domestic violence order was an abusive process and should be permanently stayed. Now, I think that has a whole lot of ramifications for some of the applications that we do see in the domestic violence court. I'm not suggesting that this authority should be relied upon in relation to all of them, but there are certainly some that clearly seem to be all about children's issues rather than about domestic violence issues. And it may be that a similar application could be made in relation to those matters. I guess I'm also concerned for those who normally act for aggrieved spouses that we may see an increase of these types of applications. So it's something to be aware of in terms of ensuring that in the application it's conveyed that obviously the dominant purpose of the application is for the protection, even though obviously the issues relating to the children may well be relevant to the consideration for the court as to whether an order is necessary or desirable. Okay. I wanted to talk then about a particular case dealing with costs in domestic violence.
So please just wait for you to had a question.
Okay, sure.
Through.
How much weight is given? Okay. I've got a question that says, how much weight is given to a domestic violence order that's been consented to without admission at an interim hearing? I would say that to some extent that's going to depend on the circumstances of the particular case. Obviously the court has to be aware of the order in terms of ensuring that any orders that they make are consistent with the terms of the protection order. A lot of people advise clients perhaps to consent without admissions to protection orders being made. It doesn't mean that there have not been any particular findings in relation to domestic violence issues made, whereas obviously if there are findings made, then the court can take those into account in determining the parenting matters. But I think it is still relevant to the interim application. It's not going to be obviously determinative in terms of whether or not domestic violence has actually occurred or not. But I'd certainly raise it in the material, and it's certainly something that should be referred to in the submission hearing as well. Hopefully that answers that question. If not, I'll look forward to the next one. All right. So in relation to the issue of costs in domestic violence matters, another one?
Going to interrupt
no,
you.
that's good. I'd rather have questions. Yes, I can. So the question is in relation to explaining the relationship between Section 68R and Section 68(2), T of the Family Law Act. And these are the provisions that deal with the power of the court in making a family violence order to revive, vary, discharge or suspend an existing order, injunction or arrangement under the Act. That's Section 68R, and Section 68T deals with proceedings to make interim or interim variations of family violence orders. Excuse me. In relation to firstly Section 68T, it relates to interim family violence orders. Those provisions only apply I guess, for a short period of time. So in proceedings to make an interim family violence order or an interim variation, then if the court revives, varies or suspends the order, that revival, variation or suspension ceases to have effect either at the time the interim order stops to be enforced or at the end of the 21-day period, whichever is, I guess, the earlier of as far as that goes. And there's no appeal that lies in relation to that particular provision, so that's an important matter as well. So in my experience, usually the court would rely upon that one if they want the parties to effectively go back to their domestic violence court to make an application for an interim variation. And that's a simpler way to go around or to get around that particular matter. Section 68R, though, is more about applications, I guess, more substantive variations. So this is, and that can be an application made by the court of its own initiative or on application of a particular person. There are some relevant considerations that the court has to take into account when looking at this. In particular, that the court has to have regard to the purposes of the division, and it's referenced back then to section 68N, which unfortunately I haven't got a copy of with me. They have to take into account whether contact with both parents is in the best interest of the child concerned, and if varying, discharging or suspending the order or injunction that was inconsistent, then they have to be satisfied that it's appropriate to do so because a person has been exposed or is likely to be exposed to family violence as a result of the operation of that order or injunction. This is the particular provision that I think some of the Federal Circuit Court judges have been a bit more reluctant to engage with, because the regulations require that a copy of the court's decision to revive, vary or discharge or suspend the order has to be sent to the magistrate's court, and there are some requirements obviously for the registry to attend to those types of matters, and there seems to have been a bit of reluctance from the courts, I guess, to impose that additional administrative responsibility in terms of those things, which is why I think there has been, if there have been ones, they've tended to have been more the interim variation, to then give the parties an opportunity to go back to the magistrate's court to seek the variation to the order in that jurisdiction. Again, hopefully that answers Louise's question. If not, please feel free to ask another one as well. But they are provisions to be aware of, and if you are doing consent orders where the time provided for or the arrangements provided for are contrary to the protection order, then I would be suggesting that you craft your orders reliant upon the relevant provisions of the Family Law Act, and make it clear that the court's varying the order so it's not inconsistent, so that the language is clear as well, because particularly if you're acting for a party who may be subject to the protection order, you don't want your client breached because it isn't clear in terms of the orders as far as that goes. All right. So if we go back then to talking about costs in domestic violence matters, for those of you who are in Queensland, you'll be aware that the provisions provide that an order for costs can be made if the application is dismissed for being frivolous, vexatious or deliberately false. And in this particular case I'm going to talk about, it was a decision by Judge Devereux on appeal. Cases RWT and BZX, and there had been cross-application originally. The magistrate had granted the wife's application for a protection order and had dismissed the husband's application and ordered costs against him in relation to that cross-application. The husband, of course, appealed. He appealed against the order for costs, but also the decision to grant an order to the wife. And I won't deal with the substantive application in relation to the wife's application, although it does make for interesting reading. Clearly the respondent in this particular case was an interesting witness. there were also some parenting themes throughout this particular matter as well, and it is worthwhile having a read of the decision just for interest sake. But in this particular matter, the Judge Devereux had some concerns in relation to whether there was a basis on which you could appeal cost order. I'd certainly be saying at the outset, I think section 164 is pretty clear in terms of the types of matters that can be the subject of appeal, and cost is not mentioned in that provision. Judge Devereux then went on to look at whether the Justices Act would allow an appeal against an order made by a magistrate, and found that it does in a summary way on a complaint of an offence or breach of duty, which doesn't seem to necessarily apply here. And then he also referred to some provisions in the Supreme Court Act and the District Court Act in relation to that. And also referred to the Uniform Civil Procedure Rules, but came back to saying that the Act had no specific provisions for an appeal against a cost order, which tends to suggest that none's available. He didn't determine the point definitively in relation to the other pieces of legislation, because it wasn't a point taken by the respondent that the appeal against the cost order was incompetent. But obviously, in his view, there was no ability to appeal against the cost order itself under the provisions of the Domestic Violence Act. Which then leads me into the last case I was going to talk about, which is in relation to the withdrawal of domestic violence applications and cost applications. So no doubt a number of you have probably been involved in matters where a party may have sought to withdraw their application either on the day of hearing or in the lead up to the hearing. In this particular case, the applicant had applied for a domestic violence order against her husband. The parties were involved in property proceedings in the Federal Circuit Court, and that did greater mention in the judgment. The wife attempted to withdraw her application at the review mention of the matter, which was about 12 days prior to the listed hearing, and the presiding magistrate wouldn't permit her to withdraw the application. And when they came onto the actual hearing date, she instead proceeded to hear the application on the papers, dismissed the application and ordered the applicant to pay the second respondent's costs, which seems quite extraordinary when the provisions of the Act make it clear that you're able to withdraw the application at any point in time. But the applicant then did something which was somewhat unusual and different. Rather than appealing, she sought a statutory order of review of the decision to prevent the withdrawal of the application and the decision to order costs. And it came before Justice Henry in the Supreme Court, and essentially he said that the rules didn't confer an unfettered discretion upon the presiding magistrate to permit or prevent the applicant to withdraw her application. It wasn't one of those cases where there might have been a question as to whether or not the withdrawal was voluntary, and so there was no cause for concern for the court. So he didn't have a concern about her ability to withdraw, and then he went on to say that even if he was wrong, that Her Honour nevertheless erred in not permitting the withdrawal of the application. And it seemed to be that the only basis advanced for there being any injustice to the respondent was that the respondent would, in consequence of the withdrawal, being allowed to be deprived of his then non-existent right to seek costs. So essentially, really the railing to allow her to withdraw the application was premised on the basis that then the respondent could make his application the cost, because obviously if it's withdrawn, there is no basis for the court to order costs in relation to the application, because there has to be that dismissal of the application. The application was granted in that particular case in terms of the judicial review. So the only other things I was just going to mention was in relation to, and I did mention briefly before, the best practice guidelines for the family courts, and the link for that document is there. It is a very useful document if you're dealing with proceedings before the court, because it does go through a number of different areas. It talks about principles around vulnerable witnesses and managing the courtroom, family and other experts, talks about the interim hearing stage, framing interim orders, final hearing, matters to consider where findings of family violence or abuse or unacceptable risk of it have been made. Then some other matters to consider and consent orders. So I would encourage you to have a look at that document when you get a chance to do so. And for those of you who are in Queensland, the Queensland Law Society have recently also issued some best practice principles for solicitors in Queensland as well, which are also useful to have a look at. There are some similarities between those and the ones that were produced by Legal Aid Queensland some years ago as well. So those are the things that I had intended to talk to you about this morning. If anyone has any particular questions, then I'm more than happy to assist as best I can as far as that goes.
Terrific. Thanks, Claire. That was a wild ride through the family law courts, so thanks for guiding us through it. Reminder folks, there are a couple of ways that you can ask questions. You can type a question into the questions box when you go to Webinar Control Panel. You can press that button that looks like a hand and we'll see your hand go up and you can ask a question that way. Looks like someone put their hand up and then got a little bit shy. Don't be shy, Jonathan. Can I ask, in more general terms, applications for costs in DV matters,
yes.
How often do you and your colleagues at the private bar seek those costs? And just a little bit more information for community lawyers who might be appearing in those matters, what considerations should they have if they're looking to recover costs in those applications?
Sure. So in relation to those particular matters, I have to set up that I'm usually appearing for the aggrieved, probably through connections with, I volunteer at Women's Legal Service, and coming from a legal aid background, that tends to be the work I do more of. So obviously, I don't make terribly many applications for costs. Having said that, and I should indicate that I haven't been on the receiving end of many applications either, because it is a fairly high bar in terms of the court having to dismiss the application as being frivolous or vexatious. And so it is a high bar, unless in that particular case that I referred to before, there were some significant reasons why the court found that or made the application for costs in terms of the cross application. I mean, there was just no merit in the husband's application. It was, if I remember correctly, they were an Indian couple, and there was a whole lot of family dynamics as well, and a manipulation of the child going on in the context of those. And so it was a fairly high bar, and in terms of actually making that cost application against them. So in essence, if there's any merit at all in the application, I think you can successfully argue that. Some magistrates obviously will make findings that there has been domestic violence, but not that an order is necessary or desirable. And in those circumstances, I think you can certainly run the argument saying, well, the court's made some findings that domestic violence has occurred. It wasn't as if the application was not without merit. There was this question that had to be determined about necessary or desirable, and the court's made a finding in a particular way, but that doesn't mean that the application was frivolous or vexatious. Does that answer your question?
Absolutely, thank you. Some questions starting to roll in. Those two. Okay. So we're just having a look at the decision in EV, which was the decision that I talked about in relation to the relocation on an interim basis and the contentious issue. And there was no independent, I assume the independent evidence they're talking about is in relation to the family violence and what do I think would be admissible as independent evidence. So in relation to that, it's obviously going to depend on the particular circumstances of the case. There may be, obviously, and the mother seemed to be critical that there wasn't any evidence provided. So if there have been, for example, family members that might have seen or heard the issues around the family violence, you could certainly file affidavit material with them. Obviously, if you've got any medical evidence or even evidence from the client's psychologist, for example, or a counsellor that they might have been seeing during the course of the relationship, where there had been issues of family violence discussed,
that would be helpful. I should say recently I've had a couple of matters where the GPs seem to be a bit more proactive in terms of asking people about family violence issues, and we've had some GP notes that have come through where the client hasn't specifically gone to see them about family violence but has been talking to them about other things, and questions have then been asked about family violence, and that was very useful and helpful evidence to be able to be used on an interim basis as well. So it's going to depend, obviously police records might assist if there's been call-outs to the home, those types of things. Recordings are a bit of a vexed issue. Sometimes people, they're helpful, other times they're not helpful at all. And certainly I would be saying to you, make sure you listen to the recording in its entirety before you decide that you're going to try and rely upon it. As far as that goes, because often recordings will sync clients rather than help them, in my experience. But those are some of the things that you might be able to identify in terms of some independent evidence of what's going on. Now we've got another question coming through from Jolene. So where a party is self-represented and it's advised by the registry that they cannot make an application, but the Act does not provide for that application, trying to make an application against an ex-wife and his partner, had experience with court making or against a self-represented applicant and those matters. Yes, I can't say I have any particular authority in relation to that. Those applications, one would hope, sorry, I don't know if I summarised that well, but in essence it's an application that really shouldn't be made where an application is being made against someone who doesn't meet the requirements of the Act. And I had this recently myself in a matter, it was a private matter though. In essence, we got, in that case, agreed to go and see the duty lawyer at the court, and after having discussions with the duty lawyer in relation to the matter, the aggrieved agreed to withdraw the application, because in my particular case it was against my client's new de facto partner who she'd never even met, and there'd been no communication or contact between them at all, so there was just absolutely, leaving aside the issue about relevant relationship, there was no basis for the application at all. In that case, I thought my client's instructions not to make any application for cost. We just wanted it to go away rather than, litigating about costs. I guess there is the potential for an application to be made in those circumstances, but I guess I would question, and it probably depends on your particular magistrate and what the history of the matter is, as to whether or not the court would be wanting to make applications in those circumstances. All right, there's then another question coming through from Jonathan saying, following on from that, then the evidence of the child should be given more weight. In all circumstances, every child should be influenced by one or other of the parent. So how could the child's evidence given in a way that could be considered by the judge with more weight? I'm assuming from Jonathan's question we're talking about in the context of family law proceedings. The issue, I guess, is in terms of getting the child's evidence before the court. I presume this is in the context of the Bondlemet decision where we're looking at views of the children at an older age. In that particular case, there were some significant issues around the influence that the father had on the child's views. The child's views are always going to have to come in through some independent expert unless there is leave obtained by the court to file an affidavit of the child, and I would not encourage any of you to make such an application. So I guess the reality is it's a matter for the judge in terms of the weight that they place on that. The evidence obviously was there in relation to this question of influence by each of them, and normally there would be either expert evidence that might support the court in making that finding, or there was evidence directly from the parties in relation to things that they might have seen or heard that indicate that there have been attempts to influence the children. So the only thing I can suggest is obviously in that particular case the father had provided evidence to say, he wasn't trying to influence the children. It seems to be, though, that in the context of the overall evidence of the case, that the court did find that there had been some attempted influence of the children. So it's obviously a matter of discretion for the court, or you can do is put whatever evidence you can get in relation to those matters and place it before the court. I'm not sure that that really answers your question, Jonathan, but there's no real easy answer to that one as far as it goes.
It looks as though that's all the questions we've got, which is great because it's smack bang on 10 o'clock. So can I, on behalf of people clapping and cheering wildly at computers across the country, thank Claire for, as I said, an exciting journey through some of the weird and wonderful things happening in family law courts and in the family violence jurisdiction of the Magistrates Court. Full stuff, I think, that's really relevant to the work that's happening in community legal centres, both in terms of the advice that you're providing and some of the representation work that you're doing in those courts. Thanks, Claire. Thanks, everyone, for tuning in, and have a great day.
Thanks, everyone.